respondent, who is the applicant in that application, that I recuse myself from further conduct on application, but who is respondent in this application is the Director of Criminal Investigations, DCI, Ms. Evelyn Onunga, working for the Office of Director of Public Prosecutions. The first respondent, who is the applicant, is represented and Kevin Ong'ondo. No formal application was filed for my recusal for further conduct of the matter, and this therefore, as it may, I will consider the oral submissions made by the parties and make a hearing for the first respondent. The submission is that I should apply wisdom, and wisdom means courage to walk away and let another judicial officer handle this matter. That I am biased, that I have handled a matter of a similar nature, and the outcome in this case is therefore predetermined. That the court has made a definite decision and the mind is already set. The second respondent stated that he agreed with counsel for the first respondent that this case go to another court, that he had lost faith in this court after delivering a ruling stating that this court has jurisdiction. Adjoined in this case is a third, a fourth, and a fifth respondents who indicated that they had faith in me to render justice and that I should continue handling the matter, that I have what it takes to handle this case, I am competent, and we should proceed. The victim family is represented by Mr. Apollo Boyer, who submitted that in an application for recusal, the party seeking a route, such a route, the victim family is represented by Mr. Apollo Boyer, who submitted that in an application for recusal, the party seeking such a route must establish the usually high standards for the basis of such an application. This is because it impugns into the integrity of the judicial officer being asked to recuse himself or herself. And this is because a judicial officer dispenses justice without fear or favor, being the oath judicial officer takes once they take up that job. That for apprehension of bias to arise, there must be factual foundations, and if factual foundation is wanting, then the application falls flat. And on the part of the victim family, they do not see any bias, for an application for recusal must be declined. In response, the applicant, the state, who is now the respondent in that application, opposed application by the first and second respondents that I should recuse myself from further conduct of this case, and relied on Article 159 of the Constitution that deals with judicial authority. That judicial authority is derived from the people, and it is exercised by courts and tribunals, and that justice should be done to all, irrespective of status. Justice shall not be delayed, and the purpose and principle of the Constitution shall be promoted and defended by the court. They also cited Article 160 of the Constitution, which deals with independence of the judiciary and imputes that the person exercising judicial authority shall not be subject to control of any person or authority. The applicant further submitted that bias, as alleged by the first and second respondents, has not been articulated, all documented by way of an affidavit or application, rendering the same as mere allegations without any footing. And as a judicial officer and under doctrine of necessity and doctrine of duty to sit, I should proceed and handle the matter with expedition. They finally concluded and stated that I have given all parties equal opportunity to canvass their preliminary application, that proceedings have been open to all, physically and virtually, and the respondents have been aware of the proceedings, and first and second respondents have also participated in the same. On their part, they have complied, and in the interest of justice, I have acted so, and bias has not been demonstrated or articulated by the first and second respondents, and therefore the state opposed the application for recusal. The Judicial Service Code of Conduct and Ethics Regulation 2020 at Regulation 47 1D and 3AB, it reads as follows, and I quote: 1. A judicial officer may recuse himself or herself in any proceedings in which his or her impartiality might reasonably be questioned, where the judicial officer, B, has actual bias or prejudice concerning a party. 3, a judicial officer may not recuse himself or herself if A, no other judicial officer can deal with the case, or B, because of urgent circumstances, failure to act could lead to a serious miscarriage of justice. I have duly read and considered all the authorities that were cited and referenced by the counsel appearing for the parties. I have looked at the case of Lawal versus Judicial Service Commission and another. Okoit was the interested party. International Commission of Jurists and another was the amicus curiae, and it was civil appeal, application number 1 of 2016, reported in 2016, case what the Court of Appeal found, and appraised also was one of the duties of the judges so to uphold. What flows from that authority I've cited is that the other persons fully aware of this case, apart from the first and second respondents, are the enjoined third, fourth, and fifth respondents. And as such, the third, fourth, and fifth respondents meet the threshold set out in that test, and I quote, reasonable, fair-minded, and informed members of the public of all the circumstances of this case. And the question I ask is, from the assessment of third, fourth, and fifth respondents, as reasonable, fair-minded, and informed members of all the facts and circumstances of this case, find me biased? And the answer is no. The victim's family, who equally are reasonable, fair-minded, well-informed members of the public of the facts and circumstances of this case, do they consider me biased? The answer is no. Does the state, being well-informed of all the facts and circumstances of this case, consider me biased? The answer is no. It therefore cannot be that only the first respondent sees bias. It cannot be that he is the only one apprehensive that he will not get justice in this court. And while the second respondent stated that he lost faith in me after delivering a ruling stating that this court has territorial jurisdiction to entertain this matter, he never cited in clear terms that I am biased. I cannot assume he alleged that I am biased by so determining. I cannot be left guessing what losing faith in me meant. Bias should be obvious to all the parties, and especially those on the same side. Alleging that I handled a similar matter and so the outcome is already premeditated, to me is outrageous. Arguing that simply because a court has handled a certain matter, it will give a similar finding is the most feeble, flimsy, and inadequate argument of all. This is because a proper court only makes a finding upon hearing all the parties and considering any mitigating circumstances that may be offered. Otherwise, if outcome is predetermined, there would be no need to approach court for orders and remedies. And considering all the submissions made by all the parties and the referenced case law, I find that the first respondent did not specifically articulate and establish any ground of bias against me. And the upshot is that the application by the first and second respondents that I recuse myself from further conduct of this case lacks merit and is dismissed. So I think we move to the application by the state. Now that it has not been I don't know if it's proceeding.